5 seconds to go. Start. The minister, being a functionary of the state, represents the state when acting in his official capacity. Therefore, any violation of the fundamental rights of the citizens by the minister in his official capacity would be attributable to the state. The state also has a positive obligation to protect the rights of citizens under Article 21, whether the violation is by its own functionaries or a private person. It would be preposterous to suggest that while the state is under an obligation to restrict a private citizen from violating the fundamental rights of other citizens, its own minister can do so with impunity. However, the factum of violation would need to be established on the facts of a given case. It would involve a detailed inquiry into questions such as whether the statement by the minister was made in his personal or official capacity, whether the statement was made on a public or private issue, whether the statement was made on a public or private platform. In Amish Devgan versus Union of India, while dealing with hate speech, the impact of the speech of a person of influence, such as a government functionary, was explained. It provides a clear instance of direct interference with the investigation by a chief minister. The court held the action of the chief minister to be wholly unconstitutional and contrary to the oath of allegiance to the constitution and imposed course on the state. The concurring opinion emphasizes the responsibility that the oath of office casts on the minister under the constitution. In Secretary Jaipur Development Authority Jaipur versus Daulat Mal Jain, while dealing with a case involving the misuse of public office by a minister, this court elaborated on the responsibility and liability of the ministerial office under the constitution. The importance of the oath of office under the constitution was also emphasized by the constitution bench in Manoj Narula versus Union of India. However, the ministerial code of conduct was held to be not enforceable in a court of law as it does not have any statutory force. An argument can be made that the minister is personally bound by the oath of his office to bear true faith and allegiance to the Constitution of India under Articles 75.4 and 164.3 of the Constitution. The Constitution imposes a solemn obligation on the minister as a constitutional functionary to protect the fundamental rights of the citizens. The Code of Conduct for Ministers, both for Union and States, specifically lays down that the Code is in addition to the observance of the provisions of the Constitution, the Representation of the People Act 1951. Therefore, a constitutional functionary is duty bound to act in a manner which is in consonance with this constitutional obligation of the state. The state acts through its functionaries. Therefore, the official act of a minister which violates the fundamental rights of the citizens would make the state liable under constitutional tort. The principle of sovereign immunity of the state for the tortious acts of its servant has been held to be inapplicable in the case of violation of fundamental rights. The principle of state liability under constitutional tort was expounded in Common Cause, a registered society versus Union of India. The position in the case of a public functionary was explained. Sri Kalishwaram Raj, learned counsel appearing for the petitioner in the special leave petition, submitted an elaborate note. This note is divided into several chapters dealing with the nature and extent of the freedom of speech, the restrictions on the same, the horizontality of fundamental rights, constitutional rights and constitutional values, statements made by ministers, and collective responsibility, self-regulation as the best mode of regulation, hate speech not being a protected speech, and the way forward. The contents of this note are summarized as follows. The constitutional mandate of freedom of expression and free speech is to be preserved without imposing unconstitutional restrictions. It is a right available to everyone, including political personalities. But even while upholding such a right, efforts should be taken to frame a voluntary code of conduct for ministers, etc., to ensure better accountability and transparency. There is an imperative need to evolve a device such as ombudsman to act as a constitutional check on the misuse of the freedom of expression by public functionaries using the apparatus of the state. The right under Article 19(1)(a) is limited by restrictions expressly indicated in Article 19(2), under which the restrictions should be reasonable and must be provided for by law by the state. Therefore, this court cannot provide for any additional restriction by an interpretative exercise or otherwise. It is too remote to suggest that the right of a victim under Article 21 stands violated if there is a statement by someone that the case was born out of political conspiracy. Therefore, there is actually no conflict of any other right with Article 21. Unlike Article 25, which makes the right thereunder subject to public order, morality, and health, Article 19(1)(a) does not contain such restrictions. Stop.